Let's talk Congress's spending power under the U.S. Constitution, and in particular, the case of South Dakota versus Dole. This is a U.S. Supreme Court case from 1987 with the majority opinion written by Chief Justice Rehnquist, dissents by Justices O'Connor and Brennan. And basically, what happened in this case was there was this piece of legislation. Congress wrote 23 U.S.C. Section 158, enacted in 1984, and it directs the Secretary of Transportation to withhold 5% of the federal highway funds otherwise payable to states from any state that permits buying or public possession of any alcoholic drink by anyone under 21. South Dakota allows people 19 or older to buy 3.2% beer, and South Dakota wants declaratory judgment that Section 158 is unconstitutional under Congress's spending power and that it violates the 21st Amendment. So they ended up losing in both of the lower federal courts. So they petitioned for a writ of certiorari to the Supreme Court, and the Supreme Court ends up holding that, well, we don't need to decide if the 21st Amendment prohibits an attempt by Congress to legislate directly a national minimum drinking age. They acted indirectly in this case under their spending power to promote uniformity in the state's drinking ages. So this is a valid use of their spending power they end up holding, and they don't end up addressing the 21st Amendment issue because it's not applicable. So as for the spending power, though, Congress can attach conditions on receipt of federal funds. That's something that they have the power to do under the spending clause. The case of Butler from 1936 concerned the spending clause, and basically that made the breadth of this power clear. Rehnquist writes, the spending power is, of course, not unlimited, but there are several general restrictions from our cases. They're not super powerful restrictions. The first is that it must be in pursuit of general welfare. And the reason this isn't a super powerful restriction is that the Supreme Court is going to defer to Congress on this. Congress makes these policy judgments about what actually is pursuing the general welfare, and the courts are going to defer to Congress. They're going to say, look, you went through the process of writing this bill. You understand what the general welfare is that you're trying to pursue, and so we are going to give you quite a bit of leeway in deciding what is in pursuit of the general welfare. So this first limitation is not some huge thing that cripples Congress's ability to actually write legislation on spending. Second, it must be done unambiguously so that states can make knowing choices. So no vagueness. Allow states to really understand what they're getting into or getting out of. Allow them the opportunity to decline, allow them the opportunity to go forward. Pretty simple stuff, putting states basically on notice. So third, conditions on federal grants may be illegitimate if they are unrelated to the federal interest, in particular national projects or programs. So yeah, you want them to be related. You don't want them to be unrelated. And there are plenty of ways in which things could be unrelated. Usually Congress at least has some sort of way to gesture at things being related. Fourth, they can't be otherwise unconstitutional under independent constitutional provisions. So if there are other constitutional provisions that might get in the way of conditions on federal spending, that could hold it unconstitutional. So what the U.S. Supreme Court says, they point out first that South Dakota doesn't actually claim that this legislation is violating any of the first three things here. They point to the last one, not otherwise unconstitutional under independent bars. South Dakota says that the 21st Amendment bans direct regulation of drinking ages by Congress. But the Supreme Court says that this really isn't true. They point out that in Butler, they established that constitutional limits on Congress when using its spending power are less exacting than those on its authority to regulate directly. That is to say that they are less powerful, they are less restrictive. So yeah, spending is a pretty powerful weapon that Congress has. Coercion, though. Coercion can be a problem as it relates to spending. It's sort of a fifth thing to look at here, a fifth limitation. But in this case, it's not a problem. It's not a problem. South Dakota is not sacrificing that much. They're not being coerced. It's a 5% federal highway fund, and that's just not coercive in the eyes of the U.S. Supreme Court because they say so. Because they say so, the Supreme Court says so, so it is the law. And then the dissent from O'Connor kind of just says, well, I don't think that Section 158 is reasonably related. She doesn't disagree with the law that they are actually applying in the majority. Rather, she disagrees with the way that they are applying it. So yeah, not a hugely aggressive dissent. Let me know what you think in the comments below. I hope that this video is helpful to you if you're studying constitutional law, if you're in undergrad, law school, any of the above, just trying to learn about constitutional law. I hope that you can take this to the bank and get an A+ on your constitutional law exam whenever you're taking it. It's still good law, so cite it on the exam. Please like, comment, or subscribe to this channel. Thank you so much for watching. This has been the More the Merrier, and I look forward to speaking to you in my next video.